Now, even if a contract is valid on its face, there is a valid offer, acceptance, and consideration. It may fail if there's lack of capacity on one of the people's parts to make the contract. There are two forms of capacity that we care about. The first is for minors. Children lack capacity. Anyone under the age of 18 can only create a voidable contract. They cannot create a completely valid contract. And remember, if you go back to our definitions, what does voidable mean? That means that the minor, the child, can terminate the contract by taking these steps: disaffirmation, rescission, and restitution. The adult to the contract cannot. They are bound. So if my daughter is 16 and she buys her first car for $2,000 and she drives it for a week and realizes that she hates the color, it's that butterscotch color, and she can't stand it. And in the meantime, her friends have all been playing a game where they shake up their Coke cans and open them in the car so the Coke cans explode. She can void the contract. What she'll have to do is she'll have to tell the person who she's bought the car from that she intends to disaffirm the contract. She has to file with the court to rescind, and she will get that. And then she has to return the car in its present condition, and she will get the $2,000 back. That's important distinction, right? Because she's returning the car in the present condition. The condition is not as good as it was when the car was originally purchased, is it? But she still gets all the money back. Why is that? It doesn't seem fair. It's for a very simple reason. The law wants to punish people for forming contracts with children because children lack capacity. So this law is deliberately harsh so that people won't contract with a child. Which is why if you ever purchased a car before you turned 18, you would have to have a parent or guardian sign. You need a grown-up. After the child turns 18, if they continue to act as if they're bound by the contract, they will eventually ratify. So now let's say my daughter buys this car for $4,000 at 17, and she's paying $250 a month, and she's been paying that for 4 months. So she's paid $1,000 of the $4,000, and now she turns 18. She's not ratified it on the day of her birthday, but let's say that she paid the first installment after she turned 18 for about $250, right? Could she disaffirm at that point? Probably. She's only a month into being 18. Let's say she waited 7 months and she continued to pay on that contract, and now she tries to disaffirm. Well, 7 months is kind of a long time. You're closer to 19 than to 18. She will probably not be able to disaffirm the contract at that point. At that point, the contract will be held to be ratified and therefore valid. I don't care how long after 18 you determine in a case. I care that you discuss why you think ratification occurred. There's exceptions, and those are for your necessities: food, clothing, shelter, and medical care. The other form of capacity is for mental impairment. Now, this is very different. Children do not have capacity. Adults do. So we assume that if you are 18 or over, you have capacity to contract, and you have to prove affirmatively that you have one of these 4 exceptions that allows you out of the contract. All right? And these exceptions are difficult. Insanity is defined by the state, and every state defines it a little differently. Brain injury can be anything from a seizure disorder you didn't realize you had, or that you did realize you had, all the way to a brain cancer. Senility, dementia, Alzheimer's, those are very tricky because older people who you are trying to hold incapacitated tend to fight you on that. They don't want to be called senile, or they don't want to lose the ability to contract. And under the influence, that could be drugs or alcohol. In Colorado, that gets a little tricky. There was a case about 2 years ago where a group of friends were together. They chose to all take acid. One of them had a bad acid trip and actually killed one of his friends while under the influence. The judge in that case decided that because the friends all chose to take the drug, that was their capacity. They chose that, even knowing the consequences. So the one individual who killed his friend was not able to claim incapacity because he was under the influence. So be careful with that one too. Here's the test for a mental mental incapacity. It's the same as for minors. It is the contract becomes voidable for the person who lacks capacity, so they can disaffirm, rescind, and engage in restitution. And that's capacity law for you.